Is your ex not following a prior judgment or order? Are you trying to figure out what you can do about it? Well, we're going to be talking about a complaint for contempt, which will make your ex do what they're supposed to do. My name's Heather O'Connor from O'Connor Family Law. So, a lot of times we get calls from people who complain that their ex isn't following a prior order or judgment. That might be because of child support, it might be a split of extracurricular activities or medical expenses. It could even be that maybe they were supposed to sell the marital home and divide the equity, but they haven't done that and they're still living there. There can be a host of reasons why the person might not be following it, but if there's a prior order or judgment that tells them what to do and they're not doing it, you have recourse. So what it is that you want to file is called a complaint for contempt. This starts a new action in court. If you already have an action going and they're not following a current order, you can still file during the pendency of the litigation. But if you've already come to a prior judgment and they're not following that, this starts a new action. So if you are the person who is complaining that the other person isn't filing, you're going to be the plaintiff in that complaint for contempt. And when you fill out that paperwork, you want to make sure there's certain things in there that need to be there. Or you could get in front of the court, they could look at your pleadings and say, I can't find the other person in contempt because you didn't fill this out correctly. So sometimes, even if you can't afford an attorney to go with you to the hearing, it might be worthwhile to have an attorney go through the pleadings with you and help you draft it to make sure that it's technically correct to present to a court. So some of those things are, one, you want to make sure their address is correct. Now, technically, a person is supposed to submit to the court if they've moved. But if you know they've moved, what you want to do is serve to their last known address as well as to where they are. And that has to be done by a constable or a process server. You cannot just mail it. You cannot just drop it off to them. Those are things that will not qualify as complete service. So make sure you do that as well. Then the court is going to want to know what the prior judgment said that you're asking them to be found in contempt of. Now, it's very, very important, and this is why it's even more important to have an attorney or ensure that you are putting down the correct legal terminology within the prior order, because the burden that you have to show within a complaint for contempt is that there is a clear and concise order that the person is willfully violating. If it's vague, if you could look at that and see that, it could mean one thing or it could mean another thing, there's a high chance that they're not going to be found in contempt, even if the judge issues some sort of order stating that they have to do X, Y, or Z. So when you're putting that in, you want to put the language of the prior judgment or the prior order that you're complaining of, you want to write that into your complaint for contempt. You also need to make sure that you have the correct date. I've seen a number of contempts go in front of the court and they've either put down the wrong month, the wrong date, or the wrong year. And the judge says, this isn't proper. So there was no order as of that date that I can find them in contempt of because the order was from a different date. It's a technicality, and it really stinks when you've gone through all the work to get into court to find that there's one little technicality that doesn't allow you to move forward. So make sure that that's correct. You can check that out on the Mass Court's website. So you can just go in, pull up your case, and see the date. You won't be able to actually see the judgment unless you're an attorney, but you can make sure that you have that date correct. You also want to put down the exact dates of when you're complaining they have violated the prior agreement. Now, if it's an ongoing child support issue, let's just say they stopped paying. You might want to put down the date that they started and a few weeks after that, and then state something along the lines and every week thereafter, or multiple dates thereafter. Some judges won't even accept that, and you have to amend it to make sure that you include every single date. that should be enough to allow a judge to find them in contempt. You also want to make sure about why they're in contempt. What is it that they haven't done? The total amount that they haven't paid. Maybe they didn't produce the children on your parenting days. You want to actually explain that. Now, if there's a reason that you know of why they didn't do a certain thing, that might be enough of a defense. So you want to make sure you talk to your attorney about what you think their defense might be or their reasons for not doing it. Because if it's justifiable, again, the judge might not hold them in contempt. They might give you some sort of recourse, but you might not get that order of contempt. And why is that order of contempt important? Well, because if somebody's not following an agreement, the judge, when they find them in contempt, can also order attorney fees. So you can get back some or all of the money that you're spending to get them to follow that order. It's not guaranteed, but you always want to make sure that you're at least asking for it, because if you don't ask, you can't get. So once you file that, you'll get a summons. They'll have to be served. The person who has been served will have a period of time to file an answer. Then you'll also have a hearing date. On that hearing date, you'll go in. Sometimes you might have to go to probation to talk about it ahead of times, but oftentimes you'll just go straight in front of the judge and you will argue why the person is in contempt. Then they'll have a chance to give their side of the story, and the judge is not going to make an order that day. If you haven't seen the video on motion for temporary orders, go back and watch that. They'll take the case under advisement, and you might not get an order for a week or 2 weeks or even a month or so. But if you want to talk to an attorney about whether or not you have a good case to file a complaint for contempt against your ex, then just give us a call. We're more than happy to talk about it and walk you through the pros and cons of any legal action that you might be taking. Again, I'm Heather O'Connor with O'Connor Family Law, and I hope you have a great day.